Okay, good morning, everyone. I'd like to welcome you to today's webinar. Before we dive in, I want to cover a few housekeeping items. We'd like to thank our co-sponsors of today's webinar, Global Minnesota, along with the Minnesota International Business Council. Thank you for the great work Global Minnesota and MIBC does in advancing international understanding and engagement. In terms of cadence today, we'll let our speakers give their presentations first and then plan to address questions at the end of the program. To submit questions, please send them in through the Q&A box, which you should be able to access through the Q&A button on the bottom of your screen, and that may pop up towards the end of the program if it's not there right now. Quick intro to Fredrikson. Fredrikson is a full-service law firm of close to 400 attorneys, 8 offices in the U.S., 4 offices in Shanghai and Mexico. We've had our offices in China and Mexico for close to 20 years now. I'm a partner in our M&A department. I co-chair our cross-border M&A group and head our Asia practice. I'm currently based in the U.S. and worked in Asia for close to 15 years in Beijing, Hong Kong, and 7 years in Shanghai, where we have our office. I'm joined by my partner in Shanghai, Mike Mayar, who has legal experience in both as a law firm lawyer, as well as a China general counsel of a global special situations acquisitions firm. He also has 8 years of financial experience as an investment banker, heading the Shanghai office of a global investment banking firm, specializing in cross-border M&A. Mike started handling transactions in China in 1995. He's been a full-time resident of China since 2008. He has represented European and North American buyers and sellers of businesses located around the world. He has experience in legal and operational issues across a wide range of industries. And Mike is joining us from Shanghai tonight. And thank you, Mike, for staying up late in your evening. And with us, as well as our partner, Rich Weiner. Rich is chair of our international group at Fredrikson and assists clients in international business transactions. His practice focuses on joint ventures, partnerships, acquisitions, distributorships, licensing, franchising, contract matters, customs regulations, and anti-corruption laws. With those introductions, I'll turn it over to Mike as our first speaker to start us off.
But thanks very much, Bob. This morning, we'll be talking about labor and anti-human trafficking laws, and we're going to be focusing on 3 key sets of laws. I'll be talking about the laws in the federal laws in the United States. We have a particular law in California that I'll also be speaking about. And then Richard will be talking about some laws that relate to human trafficking in Canada. So as we go through the presentation, I think it's important to think about some fundamental concepts as you're looking at the laws. One is that forced labor laws, forced labor laws usually concern product pipelines. So you should think about your product pipeline, your clients' product pipelines. Any people that you supply will also be looking at you as part of their product line, because this is where these issues typically come up. So one question is that if there's an issue, you have to say, well, can you document and prove, if you're questioned, that no forced labor was used in your supply chain? So these are people, you may be dealing with just on a commercial basis, but you can be asked by the authorities to document that those people that supply you are not using forced labor. Also think about, what would be the consequences for your business if allegations arose that forced labor was used in your component materials? How would that affect your business? If these are, if you're in somebody's supply chain, if your business is in a supply chain, or your client's business is in a supply chain and it's disrupted, it can have very, very big impacts on the business. Similarly, if it's your supplies that are being disrupted, it can have huge impacts. So it's good to be prepared and be able to minimize any problems that may come up from this. And the last concept that you should think about as we go through this presentation is, when will people ask you to demonstrate that you have a program in place? And we'll be talking about some of those key times when you may be asked to demonstrate that there's no forced labor in your pipeline. So the first question when we talk about forced labor is, well, what is forced labor? So I'll give you a little bit of time to, to read through each one of these slides. So you can see that the International Labor Organization has estimated that 28 million people around the globe were in forced labor as of 2021. So it's a pretty common issue around the world. So when does it typically occur? Well, it's helpful to think about the full production cycle for products, from basic raw materials to finished products, each step of the process, and consider when might forced labor be used in that process. So this slide gives the example of textiles. And when you're making an inquiry, you could be asked to look all the way to the growing of cotton, through the processing of the cotton, the manufacturing of the textiles from the cotton, the manufacturing of the final goods from that cotton. Throughout that process, there can be opportunities for the use of forced labor. Give it a little time to look at this. So you can see that there are many different companies, private equity funds, people involved in transactions, to buying and selling companies in the due diligence process. These are times when typically forced labor law issues can come to the fore. One focused area of U.S. forced labor law involves inputs that may come from Western China, from a region called Xinjiang. And this is a region of China where a minority Islamic population called the Uyghurs live. In recent years, they've received a lot of attention from governments outside of China with allegations of imprisonment and forced labor. So as a result, we'll talk about a specific law that's actually called the Uyghur Forced Labor Protection Act, passed in the United States, specifically because of this problem that's perceived by the U.S. government in China. I say more generally, when private equity funds and companies are engaged in M&A, those companies may be asked to demonstrate compliance with forced labor laws. Now, if you've been involved in M&A, this is not the time to try to develop a compliance program, or it can interfere with the transaction. It can result in reps and warranties, holdbacks. It creates a big problem for you. So the best time really is to think ahead and be prepared to have a full compliance program. Also, many retailers and brand name manufacturers, so they have asked their suppliers to document compliance with forced labor laws. So it's important to know how to do that. Right. So forced labor problems can come up at many times. And being prepared is 90% of the battle. So if a problem comes up and you have a good compliance program in place, you have a good documented program in place, you'll be able to deal with many of the issues that come up in that process. I frequently have clients who need to rapidly scramble to minimize the consequences of not preparing. It's a very difficult time. So, knowing that this law is in place, knowing that how this can affect your business really is a strong reason to prepare ahead of time. You can see the consequences can be, very severe. Like I said, one of the times that the issue comes to the fore is when goods are coming into the United States, and Customs and Border Patrol, Border Protection has the right, if they suspect that there may be goods that are coming in that were created with the use of forced labor inputs, they'll stop that right at the border. And then you have to, if you have to scramble to provide the documentation that they need, the more time that it's there, the more disruption that will result to your business. And not only you face, business consequences, you face some pretty unhappy customers. So this slide talks about, how does the Customs and Border Protection, how do they enforce labor laws? So if they, as I said, if they suspect that a shipment contains goods that were made with forced labor, they'll hold the goods at the port of entry. If they suspect that the goods were made with forced labor inputs, in order to get the products released, you must convince the CBP that the goods were not produced with forced labor. And there's very specific requirements that exist to provide that they will be seeking from you to get that documentation. And depending on what you're trying to establish, where the goods came from or that they weren't made with forced labor, you'll have different burdens of proof, and you'll have different kinds of information that they require. And all these requirements are set out in detail within guidance and policy documents that CBP puts out. If the CBP doesn't ultimately approve the shipment, then you'll need to arrange for the return or shipment elsewhere outside the United States at additional cost and expense, not to mention the problems you have with trying to replace the products that you were trying to import. So we'll be talking about several different laws that address forced labor, some of the key laws. It's also important to note that there are additional laws depending on where you're doing business in other parts of the world. But for today's purposes, because many of our clients are based in the United States, we're going to be focusing on some of the key laws that exist in the United States and in Canada. So in the federal laws is this Uyghur Forced Labor Protection Act. We also have a state act that just applies within California. It's called the California Transparency in Supply Chains Act. And then the final law, which Rich will be addressing, is the Fighting Against Forced Labor and Child Labor in Supply Chains Act. This is just a general statutory provision that exists. that prohibits the importation of items made with convict and forced labor. Another provision that addresses the situation where customs officers or even individuals, if they suspect that goods are coming into the country or may be coming into the country that were made with forced labor or child labor, they can file a petition with the Customs and Border Protection to begin an investigation. So this is the Uyghur Forced Labor Protection Act. It's, as I mentioned, it was in Xinjiang, western part of China. Sometimes abbreviated XUAR you'll see in the regulations and the guidance and policy documents. And you see there's this fundamental presumption. It's a rebuttable presumption in theory that goods from this region were involve the use of forced labor. So they assume, unless you can document otherwise, that goods from this region are made with forced labor. In actuality, it's almost impossible to meet the standard. So when you, in fact, you know, again, go back to the example of cotton, but what they'll say is, okay, well, you need to document, go back to the time that the cotton was grown. We want to see wage and labor records from the field workers to demonstrate that they were paid a fair wage. You know, we want to, at every stage of the process of the gathering of the process, the processing of the cotton into cotton material, all the way through the cotton sew operations. You'll need to provide documentation from actual documentation from each one of those steps related to the processing of the individual lots, and to show that where the lots were processed at each stage and how much workers were paid at each stage. So what people generally do, instead of trying to prove that the goods were made without the use of forced labor, is they try to prove that the goods didn't come from this region of China. Now this standard is a much easier standard to meet. However, you know, I'd also note that as far as cotton products are concerned, historically, something around over 90% of all cotton material, all cotton comes in China, comes from this region of China. So people will look very closely at claims that cotton products coming from China didn't involve cotton from Xinjiang. I also, you know, note that, you know, this particular act has very detailed regulations. There's a task force that involves several different agencies. Each one of them has their own regulations, their own guidance documents, their own policy documents, talking about the inspection process, the enforcement process, talking about what you need to do to have a good program in place to monitor and prevent the use of forced labor that comes out of China. So you can see that the Customs and Border Protection has been very active in this area. In 2 years, they've reviewed more than 9,000 shipments. with a value of over $3.4 billion. And it's not just cotton products. It's automotive parts, chemicals, electronics, flooring, solar panels. The list it expands. So they have an entity list as part of this process, and that entity lists companies that are believed by the United States government to be using forced labor as part of their operations. And these companies are not just in Xinjiang, they're also in other parts of China. And by the way, this list continues to grow. And you can also search it online. So once you have a list, you continually need to check. Every time that I have a client who has this issue come up, I need to check the current daily list of entities and of regulatory guidance documents, policy documents, et cetera. It's a fast-moving area. So you can see that they have some high priority enforcement sectors out there. So originally, you can see that they started with apparel, with cotton, silica-based products, tomatoes, downstream products. But they continue to expand. So this year, the task force, the forced labor task force has some new high priority sectors, which include aluminum, PVC, even seafood. I mean, this is Western China, so I wouldn't ordinarily expect to see a lot of seafood out of this, but still there must be some processing that's taking place. And in China, one of the things that also happens is that labor is moved around from area to area. So you could see Uyghur workers from Xinjiang ending up in a port of China. So it's useful to understand the priorities and give some thought to your supply chains. These are the latest figures showing, and I'd point out that of these shipments that were inspected, these 9,475 shipments that were inspected, 3,729 were denied. So of the ones that they suspected, they've denied 3,729, and almost, I mean, it's a little bit less than half, but it's a substantial amount of shipments that have been stopped. So given all these, the potential for problems out there, there's some key things that you can do. And it makes sense to set up a good and maintain an effective supply chain security program. In addition, you should also consider adding specific compliance terms and procedures to your procurement contracts and general conditions. So this is something that we see more and more of from across the product supply chain. Sometimes coming down from the top, and sometimes going from the importer who's going out to its suppliers, putting provisions in their contracts to ensure that there's a full compliance with these forced labor provisions. And it's not enough just to put it in your contract. You need to have an effective team, in place within your organization to investigate, to verify, and to document. In addition to the documentation, you need to have supervision that this work's been done. I've seen too many situations where people have a written program and written contracts, but there's no documentation being maintained. And that's just insufficient. No, it only takes a very small slip, and a very serious situation can arise. Especially when products necessary for the operation of your business are held up and rejected at the border. So the next law that I'll be talking about is the California Transparency in Supply Chains Act. This is a fundamentally different kind of legislation and law than the Uyghur Forced Labor Protection Act. And that's because this law doesn't stop products at the border. Instead, their approach is to focus on requiring companies to make detailed disclosures about whether or not they have a program to address forced labor issues. Now, the program is focused on large retailers and manufacturers doing business in China. But again, it can affect the entire supply chain. I think it's interesting that if you look at the program website in California, you still have the name of the California Attorney General who developed these requirements. It's the Vice President of the United States. So this is something that was a personal focus of hers, which may, again, give you some insight into how important this is on not just to California, but on a national level. Excuse me. So the basic law requires that companies post disclosures on their internet websites related to 5 areas. And we'll talk about each one of those 5 areas. The first one is that on any companies that are subject to this law, these large retailers, large manufacturers, they need to post conspicuously on their website the required information. And what when you look at the program documents, they say specifically that there must be a notice of compliance saying that the company complies with the CTSCA on the website, the website homepage of the company. So the first page that you look at for a major company that's doing business in California should be stating in large typeface, this company complies with the California Transparency in Supply Chains Act. California has also put out a 37-page resource guide, which details the requirements and including model disclosures of the provisions that California expects to see with regard to each of its requirements. So you can see the first one is to disclose to what extent, if any, the retail seller or manufacturer engages in the verification of product supply chains. So this is, again, this is not it doesn't say that you need to have this verification, but you need to say whether or not you do explicitly. You have to say whether you verify your supply chains for human trafficking and slavery, and whether or not you use third-party verifiers as part of the process. This provision, you can see, relates to the conduct of audits of suppliers to evaluate supply chain compliance. And you have to disclose whether or not the verification was independent and an unannounced audit. To satisfy this requirement, the company must state whether it audits suppliers for compliance with the company's standards for trafficking and slavery, and whether the audits are independent. California suggests that the companies describe their audit methodology, how the company selects its suppliers to audit, and provide statistics on the frequency and number of announced and unannounced audits. And this is what they expect companies to be stating on their websites on a section related to the CTSCA. Another certification is that the materials incorporated into a product comply with the laws regarding slavery. With regard to this certification, California recommends that the company provide a general description of the certification requirement and the consequences for violating. The company should include a disclosure of whether the company requires its direct suppliers to further certify that they comply with the labor laws of the countries in which they do business. Presumably all of the labor laws. And discuss any additional actions the company takes to encourage direct suppliers to comply with all relevant laws. The internal accountability. Does the company that's subject to the act, does it maintain internal accountability standards and procedures for all employees or contractors? California, again, recommends that companies generally describe those standards and procedures, including who has a responsibility for monitoring compliance. That the company provide a link on its website to the company's code of conduct related to supplier workplace standards. That the company provide general information on the types of preventative and corrective actions that it takes. And also disclose any mechanisms in place to help workers understand the company's fair labor requirements, including protections for workers who lodge grievances or report violations. There's also a requirement concerning providing information relating to training that the company engages in. What does it provide to employees, management, who have a direct responsibility within the supply chain? So they require that you certify whether or not you have this specified training in place. That so to illustrate the extent to which the company engages in relevant training, California asks that you identify the levels of the individual employees who are being trained by category or type, and also provide a general description of the nature of relevant training, including topics and general statistics regarding the duration and frequency of the training sessions that are conducted. So that's the end of my presentation, and be happy to take any questions following Richard's presentation.
Well, hello, everybody. Mike, are you still sharing?
It should be out now.
Okay. Great. Hopefully that works. Great. Hopefully everybody can see the screen.
Yes.
Well, thank you, Mike, for that great presentation, wonderful presentation, and thanks, Bob, for the introduction. I want to spend a couple of minutes today talking about, whoops, there we go. Talking about Canada's Monitored Slavery Act, also known as the Forced Labor Act in Canada. Actually, the official name here is Canada's new act against forced labor and child labor in supply chains. That's quite a mouthful, so I will simply be calling it the Slavery Act or the Forced Labor Act. And this has really become for Canada the gold standard around the world on government policies which require companies to do their utmost to prevent forced labor and child labor in their supply chains, not just in their own company in Canada, but in supply chains throughout the world, in Canadian companies or non-Canadian companies, and also to put in policies in place to eradicate any forced labor or child labor should that arise. So I'd like to spend a couple of minutes today talking about this new Forced Labor Act in Canada. It was enacted at the beginning of the year, so it's quite new. Its purpose, as I mentioned, putting policies and practices in place to prevent forced labor and child labor, and also to minimize the risk that forced labor and child labor may occur in the future, not only in the Canadian company involved, but also in the supply chain. The law is rather long, and as I said, enacted at the beginning of the year. So the government put out a couple of sets of guidance, some guidelines, initially in December, but the ones in December didn't answer all the questions. And so when the act went into force in January, there was still quite a bit of confusion as exactly what parties needed to comply and how to comply. And so then the government put out another set of guidelines in March, which answered most of those questions, but there are still some lingering questions. I suspect the government will be putting out more guidelines toward the end of the year. So I'm going to talk about how this Canadian Forced Labor Act applies to U.S. companies. So I'm assuming that those of you listening to me are working for American companies and not Canadian companies. And before I start, I should also say one other thing, full disclosure. There are some ways in which American companies are required to comply directly with the Canadian Act, and there are some ways which they are required to comply indirectly, in the sense that they have to provide information to a Canadian company, which in turn has to comply directly with the act. And so when we have an instance where an American company is required to comply directly with the act, we team up with Canadian counsel, because obviously we are American lawyers and we can't give advice on Canadian law. and we certainly can't ensure that all of the requirements of the Canadian law are being fulfilled unless we have Canadian counsel. So in the instance, and I'll speak about this in a minute, but in the instances where an American company has to comply directly with the act, then we get Canadian counsel involved. There are 5 ways in which U.S. companies might have to comply with the act, either directly or indirectly. So indirectly are the following. You're an American company, but your parent company is in Canada. You're an American company, but you have a subsidiary in Canada. You supply parts and components to a Canadian company, which in turn integrates those parts and components into a product and sells them in Canada or outside of Canada. Or you are an American company and you distribute your products in Canada through a distributor, in the sense that you literally sell your products to a Canadian company and they turn around and resell to their own customers, a true distributor. Or you are the target of a Canadian company because you might be acquired by a Canadian company, or you might merge with a Canadian company, or you might actually do a joint venture with a Canadian company. All of those are instances of indirect, a requirement to comply indirectly with this new Canadian Forced Labor Act. The only instance in which an American company becomes directly required to comply with the act is if they carry on business in Canada. And so for that, there's a test that the Canadian authorities have put in place to determine whether you have to comply directly with the act, as opposed to, as I mentioned, indirectly, which means providing all of your information and reporting to a Canadian company, which in turn has to comply directly with the act. So if you're in the situation where you're an American company, but you have to comply directly with the act, here is sort of a 5-point test whether that is indeed the case. So the first one is your American company listed on a Canadian stock exchange? And I know that's relatively rare, but there certainly are American companies that are listed on Canadian exchanges. Toronto, for example, has made quite a push in the last few years to have American companies listed on the Toronto Stock Exchange. So that's one possibility. The second one is whether your American company has a place of business, that's sort of a fixed place of business, bricks and mortar in Canada, or does your American company do business in Canada? We'll talk about that in a minute because that's vague and that's been the subject of a lot of discussion in the scholarly articles and also government guidance in Canada. What does it mean to be doing business in Canada for purposes of having to comply directly with this Forced Labor Act in Canada? Or does your American company have any assets in Canada? And there's no minimum threshold for assets. So at least in theory, if you have any assets in Canada, you could be subject directly to have to comply with the act. And so let me explain a little bit about doing business in Canada. So as I said, there's been a lot of discussion about what that means in terms of having to comply directly with this Forced Labor Act. And so the Canadian government has basically said, well, if you are a foreign company and you have to pay taxes in Canada, we're using the same criteria for determining whether you have to pay taxes in Canada as to whether you have to comply directly with the Forced Labor Act in Canada. And so those criteria, some of those criteria, the major ones are the following. Does your American company have any agents in Canada through which they do business, meaning sales rep, sales agents, that kind of thing? Does your American company have any employees stationed in Canada? Are you paid in Canada? Not in Canadian dollars, of course, but do you accept payments in Canada? Do you have a bank account in Canada? Again, American company, do you have a bank account in Canada where you receive those payments? Do you make purchases in Canada for your Canadian business? Do you solicit transactions while you're in Canada? Do you have an inventory of goods in Canada? Do you physically sign your business contracts while you are in Canada? Do you have a branch office in Canada? Do you perform services in Canada? Do you manufacture or produce your goods in Canada? And so those are sort of the criteria that the Canadian tax authorities look at to determine whether you are subject to tax in Canada. And those are the same criteria that are going to be used under this Forced Labor Act to determine whether you have to comply directly with the act. So if you, just to recap, if you as an American company have a fixed place of business, you quote unquote do business under the criteria I just mentioned, or if you have assets in Canada, then there's another step. Then do you also satisfy two of the three additional criteria that I've listed here on this slide in the prior year, last year. So if you have a place of business, or you do business, or you have assets, do you also have global revenues greater of 40 million Canadian dollars or greater, or do you have worldwide assets of 20 million Canadian dollars or more, or do you have 250 employees in Canada? If you satisfy two of those three for the prior year, and you fit into one of the categories I just mentioned, you have a fixed place of business in Canada, you quote unquote do business in Canada, or you have assets in Canada, then you are caught within the net of having to comply directly with this Canadian Forced Labor Act. Or does your American company produce, sell directly, distribute directly goods in Canada or from Canada? And so if you sell directly without an intermediary like a distributor in Canada, then you are also directly subject to this act. Do you distribute goods directly, again, without a distribution network in Canada? You don't have a Canadian company that is your distributor, so you distribute directly in Canada, then you are required to comply directly with the act. Does your business import goods into Canada which are produced outside of Canada? And again, that means you import the goods, you sell the goods directly in Canada. Does your American company have a subsidiary in Canada that you control, or do you quote unquote control another entity that's involved in any of the criteria that I just mentioned? Doing business, fixed place of business, have assets, produce in Canada, import into Canada, et cetera. If you control an entity that does any of those, then you also have to comply directly with the act. And of course, what it means to quote unquote control another entity has been a topic of a lot of conversation, discussions in the scholarly articles and in the guidance put out by the Canadian government on this. And control is what the Canadian government says, of course, it's sort of the common sense meaning of control. Are you a majority shareholder in a Canadian company? Do you control a majority of the board seats of a Canadian company? You don't necessarily have to be the immediate parent company. You can be 2 or 3 tiers up, 2 or 3 levels up. Do you control a company which in turn controls the Canadian company in some fashion as a majority shareholder, or controlling a majority of the board seats, et cetera? So rather expansive definition of control of another entity which has to comply directly with these requirements of the Forced Labor Act, and in which case then you also have to comply directly with the requirements of the Forced Labor Act. And so what does that mean to comply directly with the Forced Labor Act? What it means is that you have to send a report, you have to compile a report, we'll go through it in a minute, and send it to the Ministry of Public Safety and Emergency Preparedness. And your report has to include the following: your company's structure, business activities, and supply chain, your company's policy and due diligence activities relating to forced labor and child labor, the risks you see in your company and in any company within your supply chain anywhere in the world with regard to forced labor and child labor, and the steps that your company is taking to manage the risks that you see. The report also has to include any remedial actions you've taken, if indeed in the past there have been instances of forced labor or child labor in your company or in the supply chain, anywhere, your supply chain anywhere in the world. You have discovered this, so you know there's a known instance of forced labor or child labor, and what remedial actions have you taken to eradicate it? The report also requires you to explain the training you've provided to your employees on forced labor and child labor in your company and in the supply chain, how your company will assess whether its policies are actually effective in ensuring that if there is an instance of forced labor or child labor in your supply chain, that you can eradicate it. How effective are your policies and practices in trying to prevent forced labor or child labor in the future? So this is sort of, you are self-assessing how your policies and practices would work if indeed there were a instance of child labor or forced labor, or how it worked when there were in the past instances that you knew of forced labor or child labor. And then you also have to report in detail the actual instances of forced labor or child labor that that you know of or knew of in the past, and the steps you took to eradicate it, and how you will prevent that from happening in the future. So that is sort of in concept, all of the parts of the report that you need to put together. The report is, the format of the report is an official questionnaire, which I will show you in a minute. I'll hold it up to the screen so you can see what it looks like, but it's an official questionnaire which goes through in detail each of those areas of inquiry that I just mentioned. And once you submit your report, it goes on the Canadian Ministry's website. It goes on your website. If you are incorporated in Canada, you have to submit it to you have to provide a copy to every shareholder of your company. It has to be approved by all directors of your company, signed by the chairman of the board of your company, and it has to be submitted by May 31 of every year for the prior year. So, so this is something that you have to keep on top of every year. You have to provide a new report every year of all of the areas of inquiry I just mentioned. And once you submit it to the Canadian government, the ministry will put it on a searchable public database. So if I, for example, wanted to see whether your company was complying with the Forced Labor Act in Canada, I could go on the Canadian public database and search your company and see what you have said about your policies and practices to prevent forced labor in your supply chain, and whether you have had any instances of forced labor in the past, and and the steps you took to try to eradicate the forced labor that you discovered. So here are some just sample reports. And like I said, I'll actually put them up to the screen. I hope that'll work. I actually printed them out. I want to show you what they look like. But the first one is Hamilton Health Services. That's a rather local Hamilton, Ontario company. And what they did was they followed the format and they followed the regulations. And they have sort of an executive summary of everything that they've done in like a page or two that you could read and sort of understand what their policies and practices are. And then they've gone into a little more depth in instances of forced labor that they have discovered in the past and what they did to eradicate them. And then they went through the questionnaire. And after the questionnaire, they have the attestation, which is required, stating that all of the directors have approved this report. The chairman then signs the report, et cetera, as I mentioned, and I'll show that to you in a minute. And that's the website. If you're at all interested, you can cut and paste that, or I'm not very good technologically, however you do that, but that's the website to go to if you want to see the Hamilton Health Services report, which I found on the database. The other one here is Emerson Corporation, which many of you may know is a very large American company. But they do a lot of business in Canada, and they have several Canadian subsidiaries, and they fell within the net of the criteria that I started with at the beginning, that states that if you hit one or more of those criteria, you yourself have to submit a report. And so that is the website address for the Emerson Corporation filing their own report in Canada. So let me just show you, and I don't know if this will work too well, but I'll do my best here. This one is the Hamilton Health Services Corporation report. It might be blurred. Boy, I don't
It's
know.
blurred, and you probably want to stop sharing to make it bigger.
Oh, I'm afraid to stop sharing. That's okay. I'll skip this, but suffice it to say that as I mentioned, it's got an executive summary in it, which lays out what they have done to eradicate forced labor in their supply chain. It summarizes that in detail, and then has the rather long questionnaire that they've responded to, and then the attestation I mentioned. Emerson, sorry that you can't see it, but it's rather long as well. They put much more in prose before they got to the questionnaire. And they, for example, I'll just summarize this for you. First of all, they explain that they have several businesses in Canada, separate businesses in Canada. And in addition to the questionnaire that they filled out, the extensive questionnaire, they also explained what the structure of their supply chain was, the risks they see in modern slavery within their supply chain, the actions they've taken to prevent or reduce the possibility of that modern slavery, and the methods they've used to determine whether their practices are effective in managing the risk of forced labor as well. So sorry, I'm not technologically good enough to figure out how to show that to you on the screen. But if you go to the websites I mentioned here, you will find them. So this can be a little confusing. You don't know, as an American company, you might not know whether you have to comply directly with the Forced Labor Act and supply all the info and prepare the report and supply the information in the report and submit the report to the Canadian ministry, or whether you don't have to do anything at all, or whether you're sort of in that intermediate category where you do business in Canada, but you don't have to comply directly, so you don't have to prepare your own report, but you probably have to provide a lot of information to a Canadian company that does have to provide a report and comply directly. So it can be confusing. So all I'm saying is if you're unsure about this, reach out to me or reach out to Bob Oberlees, who started our session today. We're more than happy to walk through this with you and see whether you need to comply or whether you have to help a Canadian company comply. If you don't have to comply directly, however, but you do have to comply indirectly in the sense that you have to provide a lot of information about your supply chain and the risks of forced labor or child labor in your supply chain, then the way we've seen this occur is basically through due diligence. So the Canadian company that does have to comply directly will basically send you a due diligence request. And the due diligence request is usually because you are an American company that supplies parts or components to the Canadian company, or you sell your products to your Canadian distributor, and your Canadian distributor turns around and resells in Canada to their customers. Therefore, your Canadian distributor has to comply with the Forced Labor Act, or your parent company is in Canada, so you have to provide all this information about your supply chain, or you have a subsidiary in Canada that has to comply, so you have to provide all the information there. So there are various ways where, or you're a target of a Canadian target, a U.S. target of a Canadian company, where you might be merged into a Canadian company, acquired by a Canadian company, do a joint venture with a Canadian company, and all of a sudden you receive this due diligence request from the Canadian company saying, hey, we have to comply with this new Forced Labor Act in Canada, and we need the following information from you about your American company and your supply chain, wherever it may be in the world. And the due diligence requests that we've seen usually look like something like this. So American company, explain your corporate structure, business activities, and your supply chains throughout the world. any instances that you know of forced labor or child labor in your supply chain after, to the best of your knowledge, after due investigation. The steps you've taken to cure any prior instances of forced labor or child labor in your supply chain that you are aware of, your corporate policies and due diligence policies regarding forced labor and child labor in your supply chain, those portions of your company's activities and supply chains that pose a heightened risk, a particularly heightened risk of forced labor or or child labor, steps that you've taken in your company to assess whether your policies and practices are effective in eradicating known instances of forced labor and preventing future instances of forced labor, and how you manage these risks specifically. Steps you've taken in your company to prevent or reduce future risk of child labor or forced labor in your supply chain. This is an interesting one. Your company's actions to offset the loss of income to families affected by measures to eliminate forced labor or child labor. And this has come up in a couple of contexts, but generally it's in the following scenario. You're an American company and you have discovered forced labor or supply chain forced labor or child labor somewhere in your supply chain, and you have pressured the foreign company to get rid of the forced labor or child labor, and they have done that. But as a consequence of that, somebody overseas, an adult or a child, has lost their job, and therefore their family has lost their income from that job, which is the right thing to do, of course, because they were being forced to perform that job. But now their family has suffered because they've lost income because that job no longer exists, or the adult or child is no longer performing that job. And so the question is, have you taken the initiative to actually reimburse the company, reimburse the employee who lost his or her job because you had pressured the foreign company to eliminate the forced labor or child labor that was taking place? Have you now, do you have a policy to reimburse the employee that lost that job because of your actions? Also, on the due diligence requests, we see what training you've offered your employees regarding forced labor and child labor, whether your company's policies and procedures assess that forced labor or child labor are not being used in your supply chain, in the sense that how are you determining whether there is forced labor or child labor currently taking place in your supply chain. So that is the due diligence request, and you would, of course, send back a written due diligence report to the Canadian company, providing as much information as you can. And then it doesn't stop there, of course, because in connection with the due diligence request that they provide to you and the due diligence report that you provide with all of your answers to their questions, the next step generally, of course, is a contract. And that is, if you're a supplier, you enter into a supply contract with the Canadian company. If your Canadian company is a distributor, you'll have a distribution agreement. If you're being acquired by a Canadian company, merging into a Canadian company, acquisition documents. If you're going to enter into a joint venture agreement, into a joint venture agreement. And of course, I don't need to tell you, this is a silly slide, a funny slide, but of course, it's all going to be in writing, because this is what happens when you enter into verbal contracts. So what does the written agreement look like? What are the provisions of the written agreement that relates specifically to this new Forced Labor Act? So the first thing you should expect in any of the agreements that I just mentioned, the supplier agreement, the distribution agreement, the acquisition documents, the merger documents, the joint venture agreements, all of that, is that you have to rep and warrant everything that you put into your due diligence report. So when you answered those questions in depth that you received from the Canadians when they sent you a due diligence request and you sent back a written due diligence report, all of that information you should expect to have to rep and warranty in your contract. You should also have to rep and warranty sort of a blanket representation that, to the best of your knowledge, after due investigation, no goods and services in your company's supply chain are the result of or involve any forced labor or child labor. You should also have to expect to warrant that if your company becomes aware of or has any reason to suspect any forced labor or child labor, you will immediately notify the Canadian company, because they're going to have to put that in their report when they report to the Canadian Ministry on forced labor or child labor in their supply chain, because you are part of their supply chain. Your company, another representation or warranty that you'll have to make is that your company will develop policies, if they don't already have them, and training specifically for your employees who are involved in sourcing and supply chain roles that might have the most contact with your supply chain partners, where it might come to light that there is forced labor or child labor going on in your supply chain. And then finally, that the final warranty is that your company has appointed or will appoint a director or an officer to enforce all of the policies that you have or that you are required to have, that you will have with regard to forced labor and child labor in your supply chains. And then, of course, you should also expect, in addition to those reps and warranties, you should also expect that if you breach any of those reps and warranties, for example, your due diligence report leaves out material information about your supply chain, forced labor or child labor in your supply chain, or you actually provide material misleading statements, misleading information in your due diligence report to the Canadian company, for which the Canadian company relies, includes in their report to the Canadian Ministry, and then it comes to light that there indeed has been a violation, that the Canadian company has violated the Canadian Forced Labor Act because of your misinformation or your misleading statements or your failure to provide all of the material information. That comes to light, and then the Canadian company is fined. And the fines are generally 250,000 Canadian dollars per violation. And generally, when this happens, there's more than one violation, so it's not just 250,000 Canadian dollars. And the directors, officers, employees, and agents of the Canadian company are individually liable as well for these violations. So you should fully expect to see an indemnification clause, which basically says that if you breach any of the representations and warranties that say that you have given us full, complete, accurate, true information in your due diligence report with regard to the forced labor or child labor in your supply chain, or you've breached the blanket representation that says, to the best of our knowledge, after due investigation, there are no goods and services in our supply chain which are being made by forced labor or child labor. You should fully expect to see indemnification where you have to indemn the Canadian company for all of the damages and losses they suffer as a result of your breach, not just the violation here that I mentioned of 250,000 Canadian dollars because they got caught by the Canadian Ministry relying on your misinformation or lack of information. And then, of course, all of their reporting, and they would have to report this, they would have to report that there is an instance of forced labor or child labor. That goes into their report. It goes onto the ministry website. It goes onto their website. It goes into the searchable public database. And if all of that was a result of your breach, then they've got reputational damage. The Canadian company has reputational damage as well, for which there will be some quantifiable amount, and you will have to indemnify for that as well. So you should expect to see in contracts provisions relating to forced labor and child labor, specifically the representations I just mentioned, and at the very least, this indemnification. So with that, I will stop, and I'm happy to answer any questions that you may have. Bob, I'll let you take it away.
That's great. Thank you, Mike, Rich, for those excellent overviews. I know I learned a lot of new information. We can move on to this Q&A, and we've already received a number of good questions. If you'd like to submit a question, just use the chat function. I think that should be at the bottom of your screen. First question for Rich on Canada, and you touched on this briefly, but I think they'd like a little bit more elaboration. So what happens if a company is aware of child labor in its supply chain, but the company doesn't see any way to stop it?
Okay. So if you detect or you suspect or you actually know or you suspect that there's forced labor or child labor within your supply chain, the Canadian law doesn't make you the policeman of the world. It doesn't say that you have to do absolutely, the utmost superhuman efforts to stop that. What you have to do is you have to take reasonable efforts to eradicate the forced labor or child labor in your supply chain, and you have to document the efforts that you've taken. So clearly, you're going to discuss this with the company in your supply chain that is responsible for the forced labor or child labor. You're going to document everything that you did to try to persuade, cajole, beg this company to stop the forced labor or child labor in its supply chain, including, of course, the threat that if they don't stop, that you will no longer use them, they will no longer be part of your supply chain. But you document all of that, and it's still, in spite of all of your efforts, your reasonable efforts, they continue, as best as you can tell, to continue the practice of forced labor or child labor, and then you have extricated yourself from that relationship. You've documented all that. That's all that the Canadian law requires. Obviously, you would provide all that information to a Canadian company if they had to, if you were in their supply chain and they had to report this to the Canadian authorities. But the Canadian regulations don't require you to be the policeman of the world and wipe out all forced labor and child labor in your supply chain. They only ask you to use your, the best business practice, reasonable practices to try to get rid of it as best as humanly possible.
Got it. Very helpful. Maybe switching back to the US and a question for Mike. It seems like there are a wide range of laws and regulations relating to international sourcing and sales, not just forced labor, also export licensing, sanctions, applying to doing business with certain countries. What are some basic steps that our company can take in light of all these requirements?
Yeah, I think that's an excellent question, because all of these documents, all of these programs come, I think, essentially to the same point, which is to have a very strong compliance program put in place. And that program compliance involves having trained personnel, people that understand what the requirements are, people that do due diligence on your suppliers, do due diligence on your customers, to check the databases that exist out there, and to include the relevant provisions within your contract documents, your terms and conditions, et cetera. But I think all of these various laws, the export control laws, the forced labor laws, sanctions, they all tell you that if you're going to be doing a significant amount of international work, you need to have a program like this in place to protect your interests.
Got it. One follow-up question for Mike. Even a well-written and administered compliance program can slip up. Mistakes happen. Does having a good compliance program offer any protection if and when slip-ups occur?
Well, that's the unfortunate thing about the real world, is that slip-ups happen, right? People, just things slip through the process. The good news is that if you do have an effective program in place, and you can show that, generally speaking, that you check your customers, you check your suppliers, you've trained your people internally, then there are some formal programs in place in many of these different requirements and guidance documents, policy documents, which say that the agency will take that into account in deciding what to do. We'll take that into account in deciding whether to begin a formal investigation to seek some kind of penalty against you. Having these kinds of programs in place is a significant mitigating factor in all of them, and will really help you down the road, even if there is a slip up.
One question for Rich. What are the ramifications if my company is required to comply with the act, but it does not? I think you touched on this a little bit. Maybe you can elaborate.
Sure. So if it turns out that you have to comply directly with the act and you don't, and the Canadian ministry finds out, they basically can come to your place of business and in essence shut it down. They can come in, they can confiscate your computers, talk to your employees. So if you don't file a report at all, it's sort of like the Canadian company can do an investigation on your company until they get all the information that they want. And so they can come in, and for however long they feel it takes for them to get the information from you, going through your files, going through your computers, talking to your employees, getting information about your supply chain partners, they can come in and do their own sort of governmental audit right on the spot. In addition to any fines and penalties that I mentioned before in my presentation, they have the right to physically come onto your premises and shut it down for however long they think they need until they can get all the information regarding instances of forced labor and child labor in your supply chain, and or policies you've put in place to minimize the risk of those instances taking place in the future.
Rich, just along those same lines, are you seeing anything in terms of kind of whistleblower protections under the law? Has that been kind of clarified yet?
It has not. It's been in the guidance. So I suspect that there will be more regulations on whistleblower issues, but it hasn't been fully fleshed out. After all, this is quite a new law, and I'm expecting to see whistleblower clarifications, regulations as they proceed here.
Another question for Mike. Where can folks find more information about how to set up and operate effective compliance programs?
If you want to, do this on your own, there are a lot of good resources available online. Most of these programs will have detailed guidance documents about how to set up a compliance system, how to operate it, how to run it, how to do the training. If you want to invest the time on your own, it's possible. It's certainly possible, but you have to look at each one of the programs and follow the guidelines that they give you for setting up the programs.
Maybe a question for both Mike and Rich. What do you expect coming down the pipeline in terms of new regulations, clarifying regulations? It's hard to tell. I guess, Mike, for you, in terms of U.S. election, do you see much difference in terms of administration's approach on some of these issues? Very hard to predict that, but what are you, if you have your crystal ball, where do you see things going in the next?
Sure. From a U.S.-China perspective, what people that I've been talking to are saying is that we can see, for the existing administration carrying on. I don't see any change with, if Kamala Harris is elected president, given what she's done in the past and what she's been involved with. I think we'll continue to see rollout of further expansion of sanctions under the Uyghur Foreign Labor Forced Labor Protection Act, and the agency's announced it. I don't think she plans on stopping that. What people are saying, if Trump's elected, is They expect to see, they also expect to see some sanctions. He said that he views sanctions as a temporary tool and in fact believes it's counterproductive to have them in place for long periods of time, but sees them as a very effective short-term tool to force concessions. Generally speaking, I think that, you know, there's a sense that he would want to reduce regulatory burden out there. Yeah, but no, we'll just have to wait and see, really, obviously.
Rich, what do you see on the Canadian front? Is there, you mentioned additional sort of clarifying regulations that should be coming?
Yeah, so there have already been two sets of guidelines that have been issued by the ministry in Canada on this. Initially, as I think I mentioned, there was one last December, which laid out quite a bit of information as to who had to comply with the act and who did not, and who had to file the reports and who did not, et cetera. And then in March, and there was still quite a bit of ambiguity, and they had another set of guidelines in March. And as I mentioned, the first set of reports under this new law was required to be filed on May 31st of this year. So what I would expect is, as the ministry goes through the reports and digests all the information in the reports, I would expect maybe later in this year, another set, a third set of guidelines for information in the reports that they want to either expand, they want the information expanded on or clarified, or something where the regulations didn't quite hit the mark and people are not reporting exactly what they had expected to see in terms of information on the forced labor and child labor in the supply chains, including some of the whistleblower information that you raised. But I'm just waiting for another set of guidelines to dig deeper into exactly what information has to be submitted in the reports.
Mike, one follow-up question for you. You mentioned, like, in private equity and doing deals that whether you're on the buy side or the sell side, discovering that the company doesn't have a very good compliance program is not the ideal time to put one in. Usually these sale processes can be fairly compressed, and so scrambling to put something in place is certainly not ideal, but it happens. So if you're in that situation and you need to kind of scramble to put something together, how I guess what do you typically see in terms of how that process works?
Mm-hmm. Yeah, so that process usually, if you're involved in a M&A situation for a private equity fund, you have a company you're going to be putting up for sale, or you're buying a company and you want to, if you have a company you want to put up for sale, then you have to move very quickly to put these policies, procedures, contractual provisions in place, focusing on the major customers, major suppliers, major customers in your supply chain. And I think that's the only thing you can do. It's just a very, very difficult time to try to address these issues. The flip side is, if you have a private equity fund and you're doing roll-ups and you're buying companies, it's a good idea to make your contract standard anyway. You know, it just makes it a lot easier when you're ultimately going to be selling a company, to have a standard set of contracts, standard set of general terms and conditions, and standard policies relating to these key issues, particularly when it's a company doing international business. You want to make it as easy as possible for the exit, especially if the exit is going to be to a large multinational who's very sensitized to these kinds of issues.
And how about a scenario where the U.S. company is being sold and the buyer is doing their diligence, and they discover that, okay, they're sourcing a lot from China and they don't seem to have much of a compliance program, and we think there is even though customs, there's no history of customs holding up their shipments, we think they are a prime candidate for shipments to be disrupted. I guess, what do you do then where there does appear to be maybe some not direct sourcing from Xinjiang, but you do see, whether it's cotton or something, that you see vulnerabilities, but the client really has not substantiated or put documentation in place. What does that process look like?
Well, that makes it a real challenge for it can make it a real challenge for the sales process. It depends, in part it depends on your buyer, how sensitized your buyer is to these issues. Because they can be, if they see these kinds of issues out there and they're based on historical actions that the target company that's being acquired has taken, if it's already happened, you can't change it. So what buyers will do is they'll want to increase the reps and warranty coverage. They'll do a holdback on you, so that's obviously something that every seller wants to avoid, but that's the typical response of buyers when they see an unresolved potential liability, is put a lot of money in escrow and hold it out as long as they can.
And then otherwise, you're going to suppliers at each step in the China supply chain, trying to get certifications and documenting wage and, but again, that's going to be a several week process and not an ideal position to be in.
Yeah, it's definitely all hands on board, trying to scramble to go. You're chasing people halfway around the world to try to get verification, and people, you have to look very carefully at the verification that you're getting to make sure it's accurate and complete. So it's a real scramble when that happens.
Okay, well, sensitive to time, I think we're coming to the end of the 10 o'clock hour. And so I want to thank Rich and Mike for their excellent presentations, and particularly for Mike staying up late in his evening. Thanks again to our co-sponsors, Global Minnesota and the Minnesota International Business Council. I noted in the beginning that I think I did that the webinar was recorded. So if you'd like to receive a link, just let us know. Otherwise, thank you for joining today and have a great day.